Hello, thank you for joining us. We will start in a couple of minutes, just waiting for everyone to come on in. Thank you. Thank you for joining us. We've opened the virtual doors on today's event, but we're just going to give a couple of minutes for everyone to get in as people are flooding in. Thank you. Good morning, everyone, and thank you for joining us this morning. My name is Preston. I would like to welcome you to today's InterTrade Ireland webinar, where we will be discussing all things health and safety and addressing the government guidelines that have been put in place in response to COVID-19, including the latest regulations and employer obligations. But before we start, let me give you a few housekeeping rules. Obviously, this is a Zoom webinar rather than a Zoom meeting, so we won't be able to see you and we won't be able to hear you. That's to aid the clear delivery of our speakers today. But we would encourage you to make the most of today's session by putting any questions that you have to our speaker. You can do this at any time throughout the event. You'll notice a Q&A box located at the bottom of the screen. So please just pop your question in there, just as and when these questions come to you, and I will put them to our expert at the end of today's presentation in our live Q&A. As with all things technical, we're depending on the good graces of the internet, both connections on our end and connections on your side. So if you do experience any technical difficulties, keep calm and just send me a message using the chat button located at the bottom of your screen, and I will be able to rectify these as soon as possible. Please note that today's session is being recorded. This is to make it accessible to you and accessible to others post-event. The recording alongside the slides from today's session will also be available to download from InterTrade Ireland's website. So really that's all the housekeeping rules. That's all I have to do, apart from to hand over to Shane O'Hanlon, who's joining us from InterTrade Ireland, who will formally open today's event and introduce our speakers. Good morning, Shane. Thank you. Over to you.
Morning, Caroline. Thanks a million.
No problem.
Good morning, everyone, and thank you for joining us this morning. I know you guys are incredibly busy dealing with all sorts of issues during these incredibly uncertain times. So we're really grateful that you've come on this morning, and I really hope that you find it, a useful session, that you get something out of it. And as Caroline said, I would encourage you to use that Q&A chat function to get questions in and seek answers or seek a steer or a direction as to where you might seek the answers to those burning questions. So Just to introduce myself, I'm Shane O'Hanlon and I'm the Funding for Growth Manager with InterTrade Ireland. I wanted to very quickly talk about some of the supports that InterTrade Ireland have to assist businesses during these, uncertain times. The first of those is EBS. EBS offers up to €2,250 fully funded support to help businesses, as I say, during these uncertain times. That sort of consultancy support can be used with regards to guidance and direction to relevant government supports and help where applying where feasible. It can help with regards to emergency cash flow. You might want to seek the services of an accountant to help look at your cash flow and see what steps you could take to address any issues. Maybe look at your suppliers, look at your supply chain. It can also help with legal issues, employment issues, even hopefully not, but redundancy piece, contracts. It can look at leases, health and safety, as we're talking about this morning. It could look at, like a risk profile for your business. So there's lots of stuff that is covered under the emergency business solutions, and having become increasingly involved with it in recent weeks, I can see that on a daily basis it's helping many, many businesses. So the application form for both emergency business solutions that I've talked about and for eMerge or the links to them can be found on our website, along with the eligibility criteria. So I would encourage you to look at those. eMerge offers up to €2,800 fully funded consultancy support to help businesses, as it says on the slide there, to develop online sales and e-commerce solutions. So we've seen many, many businesses who have had either zero or very little in the way of e-commerce solutions, online sales, really moving that direction as a result of the regulations that have been put in place by the government due to COVID-19. So now might be a really opportune time. It might not be too late to get that website fully functioning or more streamlined in time for Christmas, if that's something that is a busy period. Not a busy period for all businesses, but clearly it is for some. We've seen a lot of work go in through eMerge to look at search engine optimization piece, e-commerce, as I've talked about, online payment systems in around the billing piece, product listing, packaging, labeling. So there's a lot covered on the eMerge e-commerce online sales side of things as well. So
sorry to interrupt you there, Shane. Could we move on to the next slide, please? It's just not showing, Deirdre. Apologies. Just so that everyone can see what you're talking through. I think there was just a wee freeze there. Just going to try and reshare. I'll let you keep talking, Shane, while we get those shared.
I've actually, that's pretty much all I have to say. I don't want to keep this, but I would encourage you to, as I said, look at our website, see the details of those two supports and the other supports that InterTrade Ireland have to offer around tendering, around funding, around Brexit, very, very relevant at the moment. You can look at the Brexit section of our website, innovation, trade. We're a very, very busy organization, as you can imagine, at the moment. So I would encourage you to get on, take a look at that. But that's all from me. Any queries with regards to any of these COVID-19 supports, if you could drop an email into covidsupport@intertradeireland.com, covidsupport@intertradeireland.com. I'll ask Caroline maybe to drop that email into the chat function so that you have it. Any queries, please get them in there.
We do have one question for you, Shane, and it just says, how many times can you apply for eMerge?
Given eMerge is like an offering that is put in place, like an emergency offering put in place in response to COVID-19, something that we turn around very, very quickly, the answer to that is once.
Thank you.
It is, as I've described, it's an emergency offering.
Mm-hmm. And if you've already availed of e-commerce, can you reapply to help the e-commerce package, or does that answer that? Sorry.
If you've already applied for what? Sorry.
It says if you've already availed of e-commerce, can you apply for this to help with e-com's packaging?
If you've already applied for eMerge and already got the support via eMerge, you can't apply for it again. I'm not sure just on the way it's worded. But if that support has been from another organisation, maybe Enterprise Ireland or someone, you can of course come in and apply to emerge, as long as you're not duplicating that work, if you're looking at labelling or packaging.
Wonderful, thank you very much. So thank you, Shane. We will welcome Deirdre Lynch on from Burn Wallace now, who will take us through today's presentation. And if you want to join us just on screen, please, Deirdre.
Definitely the most difficult part of things, Caroline, the sharing screen and joining you on screen. So I'm glad to have made it this far. I will share my screen now. The moment. So first of all, thank you very much to InterTrade Ireland for the opportunity to talk to you today in relation to the various health and safety law issues which arise. I think it was Darwin who said that it's not necessarily the strongest of the species which survive, but those which are most adaptable to change. And I think employers certainly in recent months and certainly since March have had to exhibit a great adaptability to change and have had to be able to change to a very significant extent, particularly in relation to employment law issues and in relation to health and safety law issues. We've gone through various lockdown periods with various and varying regulations. And certainly, I think it has been very difficult for employers to get to grips with what the various regulations mean at any given time. I'm going to take you through a very broad range of issues today. We are currently, as you all know, in lockdown in level 5. And just to look at that for a moment first and see what it means for businesses, because the impact of level 5 will be different depending on the area that you're in. So the regulations which I've mentioned there, the number 8 COVID regulations, temporary restriction regulations, these regulations are the regulations which introduced level 5 from the 22nd of October. From the radio this morning, it appears that we are going to continue to be in level 5 until the 1st of December. There is a review mechanism built into the regulations, but I think that there isn't much optimism that the level 5 restrictions will be lifted before the 1st of December. So we're going to be in level 5 until then. The regulations essentially, I mean, they do various things which are not related to employment, obviously, but in terms of their employment impact, they prohibit a person from leaving their place of residence without what's called reasonable excuse. And they then go on to define what is a reasonable excuse. So a reasonable excuse for travelling or moving includes travelling or moving in order to work, to comply with a contract of employment or a contract for services. So in other words, an independent contractor arrangement, or otherwise engage in work or employment where that work, etc., relates either to an essential retail outlet or an essential service. And in all of the circumstances, it isn't practicable to do the work or to perform the contract at your place of residence. So the regulations essentially mean that for many businesses, people will be working remotely, and we'll look at remote working later on in the presentation. There is quite a detailed list of essential retail outlets and essential services set out in the regulations. They're also set out on gov.ie, and it's very important to review that list and ensure that you're absolutely satisfied if your workplace is open, that you are actually either an essential service or an essential retail outlet. There are potential penal consequences for a breach of that particular regulation 5 of the regulations. So there's provision for a class C fine, so that's a fine of between €1,000 and €2,500 and or imprisonment for up to 6 months. So in a nutshell, the regulations mean that if you're not providing an essential service or you're not operating an essential retail outlet, then you're going to be closed until the 1st of December, meaning that many employees will be working remotely. And as I said, we will cover the issue of remote working in a little bit of detail and look at some of the legal issues which arise in relation to remote working, because it can become quite complex. The employees who are working in an essential service, or if you're in an essential retail outlet, then you're going to be working from the employer's workplace. And I think it goes without saying rather that it is essential that in respect of those employees, you comply with public health guidance and occupational health and safety law and employment laws. So to look firstly at the issue of remote working, and the first point to bear in mind in relation to those who are working from a workplace other than the employer's workplace is that you've got the same legal responsibilities to those individuals as you do to the people who are working in your physical workplace. So you've got the same health and safety obligations, you've got the same obligations in respect of working hours, you've got the same obligations, legal obligations in respect of matters such as data protection. And the legal issues which can have, are, and will continue to arise in respect of remote working. The first one is occupational health and safety law. And you know, I think the speed with which we entered lockdown in March resulted in a situation where many employees and employers, you know, carried their laptop under their arm, walked out of the office, and there simply wasn't the time. Employers didn't have the time to delve into the minutiae of the various occupational health and safety obligations which arise. So obligations like risk assessments, you know, just there simply wasn't the time to look at all of those issues. I think now that we're in a second lockdown, and certainly since it looks that possibly we may be remote working, you know, either on a continuous basis or sporadically for the next period of time, it is important to think about occupational health and safety and to take appropriate measures. And we look in a moment at the guidance published by the Health and Safety Authority on occupational health and safety law. Data protection is also very important, and there is guidance available from the Data Protection Commission in relation to remote working. It's short and straightforward, and it's easy to read. And I think it serves as a useful reminder to staff who are working from home about the importance of ensuring that data protection isn't compromised during a period of remote working. With regard to working time compliance, there has been a lot of media comment and coverage of this issue, with many surveys reporting that employees are working extra hours when they're working remotely, and that employees are consequently experiencing, you know, increased levels of stress and anxiety. Working time compliance and working time laws continue to apply where a person is working remotely, and under Irish employment legislation, and this existed long before COVID-19 reached our shores, there is an obligation to record an employee's working hours. And for those of you who are familiar with the KeyPack case from a number of years ago, if you haven't maintained employment records in relation to working hours, you will be in difficulty in defending a working hours claim, you know, where an employee says, I was required to work in excess of an average of 48 hours per week, which is the general limit which applies. If you don't have records, you will be in difficulty in defending that type of claim. Another issue which arises in relation to remote working is the issue of liability for accidents or insurance. And I think it's very important for employers to check their insurance policies in relation to remote workers. The Health and Safety Authority very recently published guidance on working from home for employers and employees. It's a very easy to read document. It's available on hsa.ie, and I would advise you all to have a read of it and to think about your own remote working arrangements and the extent to which they comply with and adhere to the guidance. The first point to note from the guidance is that the Health and Safety Authority says very clearly that there is a necessity to have a home working policy. And I certainly have seen many clients in recent months and weeks developing, reviewing or amending existing policies relating to home working, you know, to cater for the COVID-19 situation and to make the rights and obligations of employer and employee clearer. It also deals with the home office or the workstation requirements, and very usefully, sets out a checklist, so a risk assessment checklist, which I think is a very user-friendly checklist, and it would be of great assistance, I think, to employers and employees in conducting that necessary risk assessment in relation to homework. It deals quite comprehensively with the issue of work-related stress, which again, in recent months has received a lot of comment in newspaper articles. There is, the various studies suggest that employees may be experiencing increased levels of work-related stress during periods of remote working. And finally, it deals with the home office environment and what sorts of issues employers and employees should be applying their minds to in relation to what that home office environment is like in terms of light, space, heat, etc. As I mentioned earlier, the Data Protection Commission has issued guidance in relation to protecting personal data when working remotely. That's something which should be referred to in your home working policy. Employees should, as part of that policy, acknowledge that they have read and understood and will abide by that guidance, and indeed any data protection policy that you may have in place within your own organisation. The working hours, just in terms of going back to that for a moment, the programme for government refers to what's called a right to disconnect. Now, this was a right which has its origins in France and which resulted in a change to French law a number of years ago. And it essentially envisages a situation where an employee would have a right to not answer emails out of normal working hours, and to effectively disconnect from the workplace both in a real sense and in a virtual sense, in a physical and in virtual sense. And various very large organisations around the world have taken quite dramatic steps to ensure that their employees have a right to disconnect. Now, interestingly, the issue of work-life balance is mentioned in the programme for government. And we are expecting that the Workplace Relations Commission will draft a code on the right to disconnect at some point. We don't know exactly when. I think that the necessity for that type of code is probably increased given the increase in remote working and I suppose the merging of people's personal and professional lives. So that's one to watch. The programme for government also emphasises remote working, and all of this, the issue of remote working was an issue even before COVID-19 and had received increased focus at a national level. There was a consultation earlier this year in relation to remote working in July, and as a result of that consultation, the Department of Business, Enterprise and Innovation has drawn together various resources which are very useful from various sources in relation to remote working. So in relation to issues like occupational health and safety, like data protection, like training and so on. And those are all drawn together in one place on gov.ie. The one issue which has come up quite a lot, and again something that's been commented on in the media, is the issue of people working remotely from outside the jurisdiction. There have been many employees who, when lockdown happened, instead of if their normal place of work was in Ireland, they may be working remotely from a jurisdiction outside of Ireland. Now that can give rise to a myriad of issues for employers and indeed many difficulties and legal risks. Leaving tax to one side, I mean, that's a very obvious first point. The second issue is around the issue of mandatory local employment laws. So to take an example, if an employee is normally employed and works in Ireland, but for a period of time works from, let's say, France, French employment laws are not exactly the same as Irish employment laws. So the person working in France could acquire protection under specific local French laws, which may be different from Irish law. And this could become a real problem if you come to terminate the employment relationship, because there may well be, very specific entitlements under French law, which you would need to be aware of and which you would need to comply with potentially. So that can be a very complex scenario to deal with. I mean, the key point here, I think, is that you would need to take local law advice. So in that hypothetical example, you would need to take French law advice to ensure that you are complying with whatever local laws exist. Data protection, of course, is going to be potentially an issue there if the employee is processing personal data, and potentially other issues like immigration could arise also. So to move on and look at health and safety requirements in general, the 2005 Act sets out a very broad obligation on employers to ensure, so far as is reasonably practicable, the safety, health and welfare at work of employees. So that's the broad overarching duty. There are many other sub-duties, if you like, set out in the legislation with which employers are required to comply. But the duties aren't just one way. Employees also have duties. So employees must not act in a way that endangers their own health and safety or others who might be affected by their acts or omissions. And that reciprocity of duty, that dual nature of the duties is very much something that is emphasised in the Return to Work Safely Protocol, which was published earlier this year in light of COVID. And it very much emphasises the necessity for positive engagement by employees, so communication and consultation, and exchange of views and consulting on relevant issues. And it sets out many mandatory obligations, some of which we'll look at in a few moments. So you've got to, and many of you will have done this already, you've got to appoint a lead worker representative. And that person's responsibility will be to liaise with the employer and act as a go-between in relation to occupational health and safety law issues, and to ensure that the employer is complying with the protocol. Also, you've got to develop a response plan for COVID-19. So that will set out very clearly how your organisation is going to respond to COVID-19, and we'll look at that in a little bit of detail in a few minutes. Contact logs also need to be prepared, and I'm sure many of you have done this already. You need to be preparing and issuing a pre-return to work form to employees. There are also various training and prevention and control measures set out in the protocol. Talk just for a moment about PPE. So even before COVID-19, you may have had an obligation to provide PPE to an employee, and that would very much have depended on the nature of the work being undertaken by the employee. In terms of what the protocol says about PPE, so if you're dealing with a suspected case of COVID-19 in the workplace, then you must provide, as is reasonably practicable, and that's language which is very much borrowed from the health and safety legislation, you must provide, as is reasonably practicable, PPE, so gloves, masks, and various other measures are set out. More generally, the protocol emphasises that PPE shouldn't be viewed as a substitute for the other preventative measures set out in the protocol. So the provision of PPE, it doesn't obviate the necessity for you to comply with all of the various other obligations set out in the protocol. The necessity to provide PPE will really depend on your own organisation. So it's not like the protocol says you've got a general obligation to provide PPE. You must provide it if there's an identified COVID-19 exposure risk in line with public health advice. So again, that goes back really very much to assessing your own workplace and what your own risk assessments say in relation to the necessity to provide PPE. Training must be provided in relation to PPE, so in relation to using it, disposing of it, storing it, and it must be cleaned, maintained, and replaced when necessary. Just to move for a moment and look at HR issues and health and safety, and where these two areas converge potentially. And I think, I've just set out, there are many others, I've set out just a sample of some of the issues which I envisage either will be arising in many organisations at present, or which may arise at a point in the future as a result of COVID-19. And the first one is protected disclosures, or as is more colloquially termed, whistleblowing. So you could very well have a situation where an employee comes to you and says, because of your failure to put appropriate signage up around the workplace, your failure to ensure physical distancing, and your failure to ensure that there's an appropriate supply of disinfectant available and cleaning products available. I'm very concerned about my health and safety. And listening to that, you'd probably say, well, that's just a general grievance in relation to the workplace. There's nothing particularly special about that. That could potentially be a protected disclosure. And I think a very strong argument could be made that that is, in fact, a protected disclosure. So what is that? What is a protected disclosure? A protected disclosure is a disclosure of what's called relevant information, which in the reasonable belief of the worker tends to show what's called a relevant wrongdoing. And there's a list of relevant wrongdoing set out in the legislation. And one of them is that the health or safety of any individual has been, is being, or is likely to be endangered. Now, it's difficult to think of a more clear instance where it will be possible for employees to say that their health or safety is being endangered than a pandemic. So the key point to bear in mind here is that if employees are making those types of complaints, you do need to listen to them very carefully. If, for instance, the complaint is unfounded, and if you are taking appropriate measures, you need to provide an appropriate degree of reassurance. But another key point to bear in mind is that you must not take steps to the detriment of the employee as a result of the employee making that complaint. Because if the complaint is a protected disclosure and you penalise the employee for having made that protected disclosure, then you potentially face a very serious legal risk in the form of a claim under the protected disclosures legislation. So if an employee is penalised for having made a protected disclosure, then the employee can be compensated by up to 5 years remuneration, which is obviously a very significant liability for an organisation. A broadly similar potential type of claim is a claim of penalisation under health and safety legislation. And I think this is going to arise in one of two ways. So under health and safety legislation, if I, for example, make a complaint to my employer in relation to a health and safety matter, and if having made that complaint, I'm penalised, so there's some, for instance, a negative act on the employer's part to penalise me, to cause me detriment for me having made that particular complaint, then I can bring a claim of penalisation under health and safety legislation. And the legal risk here is a claim of compensation. Now, interestingly, the health and safety legislation doesn't set an upper limit for compensation, so there's no cap on compensation. Now, that said, the claims which have been brought to date haven't resulted in huge levels of compensation. But the absence of a cap on compensation is a very important point to bear in mind. The other instance where a claim of penalisation could arise in the context of COVID is where you've got an employee who says, I am leaving work today because I think I'm in huge danger of contracting COVID-19, and I simply can't take any measures to avoid that. There's nothing I can do. Now, depending on the circumstances, that could be protected under the health and safety legislation, because it protects an individual where the individual is potentially in danger and where they reasonably believe that danger is imminent and serious, and where they leave the workplace as a consequence. Now, all of that would need to be assessed on a case-by-case basis, but I can see that particular scenario arising quite commonly in the future for many employers. Another issue is selecting who returns to work, and that's going to be, I think, an issue for a lot of businesses when hopefully this level 5 lockdown is lifted. Like any selection process, or indeed like any process in an employment context, it is very important that a reasonable approach is adopted, and that you're not in any sense discriminating against one person on the basis of a protected ground. The necessity to potentially reduce the numbers of people who are physically working in your workplace may lead to a situation where you've got difficult decisions to make. So I mean, I think the best advice there is proceed slowly and deliberately, and take all relevant factors into account. The next one, I think, has been for a lot of organisations an issue to date and will be an issue in the future again, and that's the whole issue of refusal to return to work. So you could, and by return to work there, I mean return to the physical workplace. You could very well, and I think probably many organisations will have a situation where someone says, I'm not coming back to work. I'm in an at-risk category by reason of an underlying medical condition, or by reason of my age, or by reason of me living with a person who has a particular vulnerability to COVID-19. And the question becomes, well, what do you do about that if you really want the person to come back and work at the workplace? Again, I mean, in any employment law situation like this, which has the potential for confrontation, it's very important the employer acts reasonably. Given the emphasis in the protocol on the necessity for there to be a dialogue and for there to be consultation and communication with employees, the first point that you need to address in that type of scenario, and you need to get to the bottom of, is, well, why is the person saying that it's not safe to come back to work, or that they don't want to come back to work? And only when you have that particular reason will you be in a position to potentially decide on next steps. But that particular scenario has the potential to give rise to a whole range of risks for an employer, particularly from an employment equality perspective. In terms of the physical layout of the workplace and social distancing, I think many, you will probably all have had to try and address this to date, given that we're not in first lockdown stage at this stage. So first point is you need to try and maintain social distancing wherever possible. And the protocol gives a number of examples as to how that might be achieved. If it's not possible for you to maintain that necessary 2 metre work separation, then alternative measures are set out in the protocol. So you need to be asking yourself questions like, could you install physical barriers? Could you maintain a distance of at least 1 metre? Could you provide extra hand washing facilities, etc.? So what about staff returning to the office? And the protocol requires, as I mentioned earlier, a response plan. There's the overall COVID-19 response plan, and then there's a response plan to deal with suspected cases that may arise during the course of the working day. And the protocol sets out a number of points in terms of developing that plan. So who is responsible for dealing or responding to a suspected case, appointing a manager to deal with those types of cases, having an isolation area that is easily accessible, available to use in that scenario, taking account of the possibility that more than one person might display symptoms during the course of the working day, and asking yourself, do you have additional areas available, additional isolation areas available, or a plan to deal with that scenario? Can you isolate the person behind a closed door? You have to provide, an area that's away from other workers, and have you got available things like tissues and hand sanitizer, PPE, and ventilation in respect of that isolation area? So I suppose these are all quite common sense tips and points, but I think the challenge for many businesses is drawing them all together into one coherent plan and ensuring that there is absolute clarity with regard to dealing with that suspected case. So what about people coming back to the office? The protocol rather, requires employers to establish and issue a pre-return to work form. So many of you will have taken this step already, because you will have reopened after the last lockdown and probably had people come back into the physical workplace. If you haven't developed your pre-return to work form, if you look on the Health and Safety Authority's website, there is a template pre-return to work form there, which has the relevant questions included from the protocol, and which you could adopt for your organisation. One key point to bear in mind from a data protection perspective is that the questions which you ask shouldn't stray beyond what's in the protocol and what is advised by the protocol. And that's a very key point to bear in mind from a data protection perspective. So if the answers to any of the 4 bullet points there, so the person has symptoms of COVID-19 or been diagnosed or been a close contact or been advised to self-isolate, if the answer to any of those is yes, then the employee should seek and follow medical advice before they come back to the office. They're obliged to self-isolate at home and contact their GP if they have symptoms, and they're obliged to stay out of work until all symptoms have cleared. And again, that goes back very much to the dual nature of the protocol. So it's a protocol not just for employers, but also for employees. Employees also have a range of obligations. In terms of close contacts, the latest guidance from the HSE is that spending more than 2 hours in an office with someone who has COVID-19 will sometimes count as a close or casual contact, but it depends on the size of the room and other factors. And public health doctors or contact tracers will let a person know if they're at risk during contact tracing and public health risk assessments. One issue which has, again, going back to the media, has received quite a bit of media attention and comment from various bodies, has been the whole issue of reporting COVID-19 cases. And I think at the outset, there was a little bit of confusion amongst employers as to whether or not there was an obligation on an employer to notify the Health and Safety Authority if a worker contracted COVID-19. And as matters currently stand, there's no obligation on an employer to notify the Health and Safety Authority if a worker contracts COVID-19. And that is because diseases are not reportable under the regulations which I've mentioned on that particular slide. So what about data protection and adhering to guidelines during all of this, given the various obligations imposed by the protocol? So the protocol certainly requires employers to obtain personal data in relation not only to their employees, but also in relation to people who visit the premises. So maintaining contact logs, pre-return to work form, which I mentioned a few minutes ago, and if it becomes a requirement in the future, then potentially implementing temperature testing. So all of that involves the processing, the collection and storage of personal data, and in some cases, sensitive personal data in relation to matters such as a person's health. And the Data Protection Commission and the Department of Business, Enterprise and Innovation have both issued guidance in relation to the data protection implications arising from complying with the protocol. And both of those are publicly available, and I would encourage you to read them, but just to consider them in a little bit of detail. Firstly, with regard to the contact log, the guidance makes clear that the purpose of the information that's collected in that contact log is to facilitate the HSE's contact tracing procedures. And the personal data held in that contact log should not be used for other purposes. And that's very much a general principle of data protection law. There's a necessity to avoid disclosing information in relation to a particular employee's diagnosis to other employees. So you shouldn't be disclosing, for instance, if I was diagnosed with COVID-19, you should not be disclosing that to other staff. And then only retaining information for as long as is necessary for the purpose for which it is held. Again, a very common principle of data protection law. On the pre-return to work form, and this is a point which I mentioned earlier, the pre-return to work form should only collect the minimum information necessary, and you shouldn't use that form for other purposes. And it's not to be retained once the employee has returned to work. Temperature testing mentioned in the protocol, from a data protection perspective, the guidance says that it should only be undertaken in line with public health advice. The necessity here to obviously keep abreast of what the public health advice is really important. And there's not currently a public health recommendation that such testing be undertaken. The Data Protection Commission states that employers considering implementing temperature testing must be in a position to justify why any processing of personal data is necessary to mitigate an identified risk, and advice of public health authorities will be key to assessing whether it's proportionate or not. You might also need to consider whether or not to conduct a data protection impact assessment in those circumstances. Moving on to look at risk analysis and templates and plans and what sort of guidance and trying to draw it all together. So there is on the Health and Safety Authority's website a general guide to risk assessments and safety statements. And of course, in reopening your workplace in light of COVID-19, there is a necessity to update your risk assessments, possibly also update your safety statement. And there is useful guidance, general guidance on the Health and Safety Authority's website in relation to that. I mentioned earlier the guidance on remote working, and I would encourage you all to refer to that guidance. I think it's very useful, a very useful document, and I think, you know, taking it, reading it, and incorporating the various measures into your workplace will assist you now in complying with your occupational health and safety obligations, and in turn assist you in the future in defending any claim if a claim materialises. Other important documents are obviously the protocol, which I've mentioned at length, and the department's explanatory guidance on the data protection implications is also a very useful document to read, as is the Data Protection Commission's guidance in relation to the protocol. I mentioned earlier the Health and Safety Authority and the various templates and checklists which are available on its website. I would really encourage you to refer to those. They're very useful in setting out a roadmap for you in order to ensure that you are complying with the protocol as an employer. So various issues are dealt with, like induction, cleaning and disinfection, the lead worker representative, and they're all done in a very user-friendly format, in a kind of questions and answers format. So they'll assist you to address what issues you need to take action in respect of, and to track that action. So what about your health and safety policy? Under the 2005 Act, an employer is required to have what's called a safety statement. Now, a safety statement is a document which sets out the risks and the hazards of the workplace, who's responsible for various health and safety issues, what sorts of measures are being taken to try and avoid those risks materializing. So it's your plan of action to ensure, insofar as is reasonably practicable, safety, health and welfare at work. Given that there are going to be in many cases, very far-reaching changes to workplaces and work activities as a result of complying with the return to work protocol, then it will be necessary for organisations, if you haven't already done so, to conduct a risk assessment and then to review your safety statement, where, for instance, there may have been a significant change in relation to the matters which it addresses. So you need to do those risk assessments if you haven't already done them, and update your safety statement. Just to look for a moment and very briefly at the issue of mental health and well-being. And again, various reports and various surveys suggest that many employees, and I anticipate many employers, are suffering from increased levels of anxiety and stress as a result of the very traumatic situation in which the world finds itself, and indeed possibly also because of traumatic events experienced in people's personal lives as a result of this terrible pandemic. The working from home has been quite burdensome for some people, and others have really enjoyed it. But many clients and many employers are saying, you know, I think that ex-employee or ex-employees may be not coping terribly well with working from home. So what do you do as an employer to try and ensure that you put in place the necessary supports? I mean, many organisations have an employee assistance programme. I think now is a good time to remind people, if you have that kind of programme in place, now is a good time to remind people of the availability of that programme, and you could just do that by way of email. Communication, and I mean, it sounds trite, but it is a key point here. Communication is really important. I think many people have struggled with, many managers have struggled with remotely managing workers. And as an employer, you may need to consider issues such as, does my manager X require additional training in order to be able to manage her team? What sorts of training programs might I put in place? Issues such as, regular contact with people on your team, obviously very important. And if possible, doing that via video link rather than via telephone, because it's obviously just much more personal, and I think helps people to feel connected to the place in which they work and to the organization for which they work. But it's certainly an area which employers need to be focusing on. And if warning signs are there, you need to think about what steps, be that training, be that increased communication, be that encouraging someone to take her annual leave, what sorts of steps like that you might take to try and avoid the potential of a fallout down the line. And finally, then, just to look at the issue of training. So various forms of training are required by the protocol. So the lead worker representative has to get what's called necessary and relevant training. Now, there's nothing in the protocol which tells you what is relevant and what is necessary. I think what is necessary will be very much a function of the level of experience and knowledge of the lead worker representative who is in your organization. Some people will require more training than others. COVID-19 induction training has to be provided to all workers. Now, I anticipate that many of you will have provided that training to your staff before they came back to work, after they came back to the workplace after the last lockdown. If you haven't done it, then you should be doing it before people return to the workplace after this lockdown is hopefully over. Other issues in respect of which advice and training needs to be provided. So how to perform hand hygiene effectively, that's another issue. As I mentioned earlier, you might think about other types of training. So do you need to train managers in how to manage people remotely? Are there ways in which your employees' roles have changed because of COVID, which necessitates their having extra training or some particular form of training to enable them to carry out their roles effectively and efficiently? So that has been very much a whistle-stop tour of various issues which arise from a health and safety perspective. And I'd be happy to answer any questions that you have in relation to the issues that I've discussed.
Thank you so much, Deirdre. That was so detailed and really, really helpful. At this stage, I'm going to open the floor to questions, of which we have lots flooding in. We will try to get through as many of them as we can within the time. Obviously, this morning's topic is very complex and it's very confidential, so I won't release the names of those who are asking the questions. I think that's important. And it's also important to note that Deirdre will obviously try to signpost and provide general pointers as best she can, but it should not be adopted as legal advice, and you should either contact Deirdre post-event, which I'm sure she'll be delighted to help you, or your own personal advisor. So let's get right into question number one. So Deirdre, you went over the topic of measures within the workplace, but could we look at what about staff working in vehicles? This person has said, we have staff travelling separately in company vans to essential sites, but we've also noticed that some companies allow their staff to share vehicles as long as they wear masks and gloves, and other competitors are putting dividers in the cabs. Do you have any guidance that you could provide in that area?
I mean, I think from a health and safety law perspective, the safest way for people to travel is separately. And that's something which is very much encouraged by the protocol, that people should be traveling separately. You should also be, I mean, for instance, you could have a scenario, and I'm sure this arises quite commonly, where, vehicles are not just used by one individual. If that's the case, I mean, I might use the vehicle today and someone else might use it tomorrow. I think you need to try and avoid that insofar as you can. If that's not possible to avoid, which it may not be, then you need to put in place appropriate cleaning systems, make available tissues and disinfectant and all of that to ensure that appropriate steps are taken to try and make it as safe as possible. But in answer to the question, I think people should be travelling separately. That's obviously the safest way.
Yes. The next question came in quite early. So I questioned whether it was in relation to essential working, but with regards to interviews, does that qualify as a reasonable excuse for travelling around the country? So does that?
It's not something which is specifically set out in the we'll call them the number 8 regulations. There's nothing in there that says you've got a reasonable excuse if you're going to an interview for a job. So I think the answer to that is you should be doing it remotely. Now it may be that the person is interviewing. I'm not sure the nature of the role in question. I wonder, is the person interviewing, for instance, for an essential service role or to work in an essential retail outlet? But even at that, I mean, I think if you can, you should be doing it remotely. It's certainly not something that's specifically envisaged by the regulations, and I think you could be in breach.
Absolutely. The next question is in terms of when you're working with clients face to face, how does this fall under health and safety? Who is ultimately responsible for the safety of staff? And I question, when I'm reading this question, do they mean out at client premises rather than at their own premises? But
yeah. I mean, if we try and forget about COVID for a moment, and think about a normal scenario. So, like if for instance a client visits your office and there's a slippy floor, just to take a straightforward example, and the person falls, the person can potentially bring a personal injury action against your organisation. So it goes back to trying to ensure that the premises is as safe as possible. So if you've got clients visiting, you'll need to be asking appropriate relevant questions in advance in relation to, you don't want a scenario, for example, where a client visits your office and the client is displaying symptoms of COVID-19 and then you've got a COVID-19 outbreak. So you do need to obtain, you're going to ask certain questions in advance. You need to be careful about how you hold that data. You need to ensure that there's physical distancing in place in the same way that you would in any scenario nowadays. And those are the kinds of measures that you should be taking. But I think that at present, because we're in level 5 lockdown, you're not, for most businesses, that's not going to be a reality at present. And most businesses should be, unless they're an essential retail outlet or they're an essential service, they should be undertaking meetings remotely. Now, I know that's not as good as it is in reality and in person, but unless you're in those essential services, essential retail outlets, it should be remote at present.
Yes, but certainly that's helpful for a go-forward basis when we come out. The next question looks like it's through from someone in construction. If you have a mobile working force, such as construction, would you have any suggestions of how to set up isolation areas that you were talking about?
Yeah, I think that would have to be assessed based on the particular site in question, how many people are working on the site, what are their working patterns. So I think that's a question that I'd have to have more information to be able to answer in a specific way.
Absolutely. The next one might be down employment law, but if an employee is staying at home during lockdown, and this includes both lockdowns, because they've requested to do so when they feel unsafe and they have underlying conditions. As the employee, we've tried to be accommodating and allow for this, of course. However, the employee is now due to return to work on the 1st of December, and our employment contract states that no holidays can be taken in the month of December or carried over. Does this employee have the right, when they return on the 1st, to take their holidays owed during December, which is a month which they don't allow them?
Yeah, and the issue of taking holidays and when holidays are taken, so it's up to the employer when I take my annual leave, but in in relation to that, the employer needs to take account of my need for rest and recreation and my need to reconcile work and family responsibilities. So you could conceivably have a situation where the Workplace Relations Commission might say, well, look, it was unreasonable in these particular circumstances not to let that person take any annual leave because she didn't have annual leave for X number of months. So it would need to be looked at on a at a specific level. But I think that ultimately it's up to the employer when the person takes annual leave, subject to taking into account the need for rest and recreation and the need to reconcile your home and your family with your
Absolutely.
workplace.
Thank you, very helpful. If you have someone who tests positive for COVID-19 but was asymptomatic, should you not disclose that, as everyone in the workplace would be at risk?
Well, there's a fine distinction here, I think, to be drawn between you're not going in that scenario. You're not going to say, for example, Deirdre Lynch tested positive for COVID-19. You may possibly say, you may have to take measures. You may have to leave people at home or get people to work from home in that scenario while you carry out the necessary, disinfecting processes and cleaning processes. And so on, because otherwise, as the questioner says, you're potentially creating a very big risk to other employees. But the point I was making is that you're not going to be disclosing an individual's personal data and saying that particular individual tested positive. You may say that there was a confirmed case of COVID-19 within the organisation. We are taking the necessary preventative and control measures to try and minimise the risk to health and safety, but certainly disclosing an individual's own sensitive personal data in that way would not be appropriate. But the questioner is right. You will need to consider what steps you need to take to minimise the risk to others.
Thank you. I think we have time for a couple more questions. The next one says, did you say the return to work should be destroyed after review?
So what the Data Protection Commission guidance says in relation to the return to work form is only hold it for as long as you need it. So the guidance says from a data protection perspective, destroy it once the person returns to work.
Okay, thank you. A few more questions. What sort of legal issues will arise in relation to employees refusing to return to work when the lockdown is lifted?
Yeah, I think a very short answer to that question, which lawyers are probably not terribly well known for, is lots. I think all sorts of issues are going to arise. So I think, and I've seen a lot of these so far. So people are going to say, for instance, people may say, I am not comfortable coming back. So for scenario one is, I'm not comfortable coming back to work because I don't think you as my employer have taken appropriate measures to protect my health and safety at work. So in that type of scenario, there's no particular specific protected reason that the person is advancing. So they're not saying, I'm not coming back because I'm in a particular age category. I'm not coming back because I've got a vulnerability. I think in that scenario, you need to talk to the person. You need to find out what exactly her or his concerns are, and provide a degree of reassurance if you can, or take appropriate measures if you've been deficient in some way. Others will say, I cannot come back because I've got a particular vulnerability. I cannot come back because I'm in a particular age category. So how you treat those employees could give rise, for instance, to a claim under the Employment Equality Act, so a claim of disability discrimination. The reason I say that is the definition of disability is very, very broad. So under employment equality legislation, so if I say I'm not coming back because and you try to force me back, I may say that you're discriminating against me on the grounds of my disability. Similarly, age is a protected characteristic, so you need to think very carefully about how you deal with refusals by workers who say, I just simply don't want to return to work because I'm an older worker, I'm X age, and I'm really worried that I'm going to contract COVID-19. So those are the Employment Equality Act considerations. Separately, I think, if it were to transpire that you compelled someone to return to the workplace and that person developed COVID-19 and became very unwell, you could face personal injury actions from employees. Now, I think that would be a tricky one from the employee's perspective to a tricky claim to make out, because how do you establish that it was my return to the workplace that caused me contracting COVID-19? But I mean, it could be a runner in some cases.
Yes. Well, thank you so much, Deirdre, for answering those. I am very conscious of time, so I'm going to wrap up our session there. I hope that you've all found this event very useful. Thank you to Deirdre, thank you to Shane for your time, for your input in today's session. And please don't hesitate to get in touch with us. I've put the email address in the chat below, so note that down please before the session ends, and you can put those questions, whether they're for Deirdre, whether they're for Shane, and COVID support at InterTrade Ireland will direct your query accordingly. So all that's remaining to say is thank you for your time, thank you for joining us, and stay safe.